Good morning, everybody. This is Monica Hernandez with the Sacramento Area Council of Governments, and it is my pleasure to welcome you to the webinar today. Just a few housekeeping notes. This webinar is being recorded and will be provided to you via email following the presentation. Here at SACOG, we have James Corliss, Chief Executive Officer, Christina Lockey, Policy Manager, and myself. And I would like to quickly turn it over to James Corliss to say a few words.
Thanks, Monica, and thanks for everybody for joining us this morning. I am sure we don't have to probably impress upon all of you how serious a challenge we have in housing in the state of California and in a 6-county region here at SACOG. Certainly, it's been on the top of everybody's mind what the legislature has been able to accomplish and pass and get the governor to sign this year in terms of the housing package. This webinar is, I think, really going to be your opportunity to hear from some experts, to ask some questions via the chat function, and to really understand how we can take advantage of what the legislature has done over this session for housing. I would say, and I would really direct each and every one of you to SACOG's Regional Progress Report. Earlier this summer, we really looked at the region and a lot of our indicators since the year 2000 in terms of how we're doing, how we fared during the recession, which was not well, how we're bouncing back pretty strong from the recession. But one of the many great pieces of information, but frankly very sobering in that Regional Progress Report that's on our website, is that we are significantly underproducing housing of all forms for all income levels, but especially affordable housing. And we are underproducing in a very big way attached product and infill housing. So one of our questions really as a region is, how can we take advantage of this housing package to really begin to kickstart really big way a lot more infill development, attached product, and affordable housing? What did we naturally not accomplish in this housing package in 2017, as far-reaching as it may have been, that really was still left on the table that we still need to tackle in terms of making sure that we really are getting behind infill and attached product in this region, which, as our market demand studies show, is going to be more and more in demand. So with that, again, just thrilled to have everybody on the call this morning in the webinar, and I will turn it back over to Monica.
Thank you, James. And as you saw in your registration, we are very pleased to have Barbara Kautz and Eric Phillips from Goldfarb Lippman. Barbara is a partner with Goldfarb Lippman and practices extensively in the areas of land use, CEQA, NEPA compliance, real estate, and affordable housing. Prior to joining Goldfarb Lippman, she was a practicing planner for 30 years and served as the Community Development Director and City Manager for the City of San Mateo here in California. Eric Phillips is an attorney with Goldfarb Lippman, practicing in the areas of land use, CEQA compliance, community development, and affordable housing. Prior to becoming a lawyer, Eric worked as an urban planning consultant, and he has been thinking about and working on issues around housing professionally since 2002. And before we turn over our presentation, we'd just like to get a quick sense of who is on the call today. So we have a quick poll that will be going up on our screen. And that should be, we're collecting some responses here. And we're essentially looking at who was in the room. We have almost everybody's voting here. Are you there? We're having a bit of a challenge. All right. And we are going to share the results here really quickly. And you are all viewing the polling results now. So we have about 61% of you in local government, 4% from the state legislature, 0 affordable housing developers, a few market rate, and then a few consultants. All right, thank you very much. And with that, we are going to get ready to turn it over to our presenters. 1 second, we'll be changing our screens over. And Barbara and Eric, you now have audio, and in just 1 second, your screen will be transitioning. There we go.
All right. Well, thank you. I'm Barbara, and Eric's next to me, and thank you very much for inviting us to do this presentation. So we want to give you an overview of what we're going to be discussing today. First of all, we want to talk about changes that will affect the processing of housing applications that will be effective on January 1st, 2018. And there's a series of bills that affect the Housing Accountability Act. There's SB 35, which everyone's heard of, and then there's the No New Net Loss statute. And after we discuss those, we are going to take questions because we've been presenting this to various groups, and those are the bills on which people seem to have the most questions. And then we'll return with some other new laws, some of which will be effective January 1st and some of which won't affect agencies until later. There are, as everyone knows, there were 15 bills in the package plus a number of other housing bills that the governor signed. And so we're going to focus on the ones that will affect everyone January 1st and that people need to prepare for now. So I'm going to talk about so here are the 3 bills again, summarizing the bills that affect housing applications. And I'm going to talk about the Housing Accountability Act changes. Now, the Housing Accountability Act has been in effect since 1982. But it's generally been perceived as affecting only affordable housing, not market rate housing. In fact, it does apply to all housing development projects, and those are defined as including residences only, transitional and supportive housing, which is a category defined in the housing element, and then mixed-use projects. And this year, the bills expand the definition of mixed-use projects to include any project where at least 2/3 of the square footage is designated for residential use. In these slides, we've shown any new language in red so people understand the changes that have been made. So the piece of the Housing Accountability Act that applies to all housing development projects, whether market rate or affordable, is this provision. And then which states that if a project complies with, quote, objective general plan zoning and subdivision standards, it can only, the density of the project, the number of units can only be reduced or the project can be denied if there's a, quote, specific adverse impact to health, public health and safety that can't be mitigated in any other way. And you see that we've highlighted some new language about indicating that lower density might include something that would have the same effect on the ability of the project to provide housing. So the first case in which this was applied to a market rate project is this Honchero case, which was decided in 2011. So issues here. What is an objective general plan and zoning standard? The Housing Accountability Act doesn't define what objective means. SB 35 has a definition of objective, although it says that definition is limited to SB 35. Nonetheless, it may be of some help in understanding what that means. And SB 35 defines objective as standards that involve no personal or subjective judgment by a public official, uniformly verifiable to an external and uniform benchmark, and knowable by both the development applicant and the public official prior to submittal. So what would be an objective standard under this definition? Height, setbacks, coverage, open space, so forth. You know, design criteria to the extent they're objective, street width. What's not objective? Things that are often included in making decisions on projects: the character of the community, the look and feel of the community, suitable for the site, and so forth. And the other issue is so if it meets objective standards, the project's only supposed to be denied if there's a specific adverse impact to public health and safety. And what's a specific adverse impact? It's defined as something that's significant, quantifiable, direct, and unavoidable based on written public health and safety standards as they existed on the date the project was deemed complete. So it's a very tough standard to meet, and probably if you could meet the standard, if the project didn't comply with a public health and safety standard, it probably didn't comply with an objective standard anyway. So in the Huntroost case, the court told actually the county how they should make a decision if they wanted to deny the project or reduce the density of the housing project. And that was, initially they could try to identify objective standards the project didn't comply with, or if the project complied with all the standards, then they would have to be able to make the public safety finding. The court really didn't get into a discussion of what objective means, but did say that suitability for the site was not an objective standard. So there have been several Superior Court decisions recently where developers or people advocating on behalf of developers have gone to court to argue that the denial of a housing project violated the Housing Accountability Act. This was a small project. There were three. This home was to be replaced by 3 units. It was designed because the neighbors opposed it, and the council decided it wasn't consistent with the character of the site. And the court said that wasn't an objective standard, that the project met all the objective standards. Interestingly, the lawsuit was not brought by the developer, but by one of the YIMBY groups in the Bay Area called the Bay Area Renters Foundation or San Francisco BART. This was a more significant use of the Housing Accountability Act. It was a 320-unit project developed under a very detailed, specific plan. The developer provided evidence that the project complied with all the objective standards, but the city denied it because stating that it didn't comply with the look and feel of the community. The Superior Court told the city to reconsider the project, said none of the findings were based on objective standards, and the city did ultimately approve the project based partly on a staff report saying it complied with all the objective standards. Now, the Housing Accountability Act also has additional protections for affordable projects, which we're not going to go through because they haven't changed. But if there's an affordable project, which can be one that has 20% low income or is 100% moderate or middle income, even if the project doesn't comply with objective standards, one of these additional findings would need to be made. The change in the Housing Accountability Act that will have, I think, the biggest effect on processing of applications is this one. A city or county has to provide the developer of a housing project with a list of any inconsistencies with any, quote, plan, program, policy, ordinance, standard, etc., within 30 days after the project is deemed complete, if the project has 150 units or less, or within 60 days if it has more than 150 units. The city or county needs to explain why the project is inconsistent, and if it fails to list an inconsistency, the project is, quote, deemed consistent with any standards not listed. There's an issue about how to treat projects that were deemed complete before January 1st, 2018. We don't have an answer about whether this provision would apply, whether cities need to provide this letter in the first 30 days of 2018. The statute just didn't deal with that. In general, the other changes in the Housing Accountability Act reduce deference given to local government decisions. Any findings have to be based on a preponderance of the evidence in the record, not substantial evidence. So if a city or county receives evidence on two sides, it needs to explain why it thought one side was better. There's also a provision that a project will be deemed consistent if, quote, substantial evidence would allow a reasonable person to conclude it's consistent. Essentially, this tips the balance in favor of finding a project consistent, because unless there's nothing reasonable that would allow a court or the city to deem it consistent, it's considered consistent. And attorney's fees have been expanded to both market rate and affordable projects. And finally, there's a number of complicated provisions that allow a court or direct the court to impose a $10,000 per unit fine if the city is ordered to comply with the Housing Accountability Act and does not. A couple of comments. I don't think too many decisions are in, too many of the SACOG cities and counties are in the coastal zone, but there is a decision indicating that the coastal zone trumps the Housing Accountability Act, and the projects are still all subject to CEQA. And the city must make all findings required under CEQA and to certify the environmental document before a developer can invoke the Housing Accountability Act. These two cases discuss how the Housing Accountability Act applies to CEQA. So with that, I'm turning the microphone over to Eric, who is going to discuss the SB 35 streamlining provisions.
Thank you, Barb, and good morning, everybody. So as Barb just mentioned, I'm going to spend a little bit of time describing the mechanics of SB 35, and anyone who followed the last legislative session or read a newspaper about the housing crisis and the legislature's response to it probably heard something about SB 35. This was really the centerpiece of the coverage that was received. However, as you see, we're going to walk through the three levels of analysis that are required to qualify to use SB 35. We think its ultimate reach will be more limited than the changes in the Housing Accountability Act, for example, that Barb just walked us through. But let's dive into some of these details, and we can explain why we think that's the case. So, as I mentioned, there's a three-step process to determine if a project is eligible to take advantage of SB 35. As an initial matter, the jurisdiction has to be subject to SB 35 by not issuing enough building permits to satisfy its RENA. That project then has to be consistent with all objective planning standards that the jurisdiction applies to that project. And then it also must meet affordable housing and labor requirements that go along with it to remain eligible. If a project is eligible, there's still a number of physical exclusions and exceptions to SB 35 that will knock out a number of other projects. But if you do make it through all three levels of this analysis to qualify, it really is a powerful tool, because SB 35 requires then ministerial approval for all projects that meet the objective standards and qualify for SB 35's provisions. And once a project is eligible for ministerial approval, it is no longer subject to CEQA, because CEQA only attaches to discretionary actions by public agencies. So this process then becomes a way to streamline and keep projects exempt from CEQA review. Diving into that first level of analysis to see how a jurisdiction becomes subject to SB 35, it's important to understand the regional housing need allocation, or the RENA. This is a key component of every jurisdiction's housing element. Since most of the people on this webinar are public agencies, I'm sure that you're familiar with these provisions. But in general, the RENA represents every jurisdiction's share of the housing demand that's projected for the 8-year housing element period that the jurisdiction is within. And the typical breakdown for a jurisdiction would be 40% of the units having low and very low demand for low and very low income housing. 20% of the units in a jurisdiction are designated from households with moderate incomes, and 40% of the households in a jurisdiction are designated for households with above moderate incomes. And in our model city here, you can see we have assumed 1,000 units of RHNA, 1,000 units of their share for the 8-year housing element period, and that breaks down to 400, 200, and 400 units following those percentages. And the way SB 35 works with that is that if a jurisdiction is not issuing enough building permits to satisfy its RHNA by income category, then projects that qualify for SB 35 in that jurisdiction are required to be approved ministerially. And specifically, SB 35 focuses on the production of the lower income and the above moderate income categories. So every year under SB 35, jurisdictions will be required to submit an annual report along with their housing element reports that show the number of building permits by income category that have been issued. And if you're not keeping up with your production, you will then be subject to SB 35 either until the midway point of the housing element cycle, or if you're already past the midway point, till the end of that housing element cycle. So it's a 4-year window. And what that means, again, if we look back at this model jurisdiction I was talking about, if we assume 400 units of lower income over the 8-year period, that averages out to 50 units of lower income housing per year. So that's 50 building permits to construct those lower income units every year. Otherwise, your jurisdiction is subject to SB 35. Once you've been determined by HCD to be subject to SB 35, then the projects that are eligible, as I mentioned, get ministerial approval. And to be eligible for SB 35, a project must propose 2 or more units. It has to be in an urban area with 75% of the perimeter developed. It's really focused on these urban infill opportunities and trying to promote development in that style. The site must be either zoned or planned in the general plan for residential use, and mixed use is okay as long as residential use is permitted within that district. And it must be, as I mentioned before, consistent with all objective planning standards. And this uses that same definition of objective that Barb discussed when she was reviewing the Housing Accountability Act. I will also mention that if a project is modified by using density bonus, so it exceeds the density or other height, setback, other requirements that would otherwise apply to the project, it is still consistent for purposes of SB 35. So modifying a project by density bonus, even if you're not technically consistent with the objective standards, doesn't keep you from being able to use SB 35. As I mentioned before, there's also a financial component to qualify for SB 35. And projects must meet both affordable housing requirements and project labor requirements in order to take advantage of these provisions. For the affordable housing requirements, these will be determined based on the local jurisdiction's affordable housing and above market rate housing production. So if you're in a jurisdiction that has not met its RHNA for the above moderate income category, then any project with 10 or more units of housing has to reserve 10% of those units for lower income housing. If you're in a jurisdiction that hasn't met its lower income housing requirements, then 50% of the project has to be designated for lower income housing. And if you're in a jurisdiction that has not met both its lower income and its above moderate income, then the applicant gets to pick whether it uses 10% or 50% affordable housing production requirements. So if you think back to that chart that I showed earlier with the 400 units of lower income housing, almost every jurisdiction is going to be subject to SB 35 because it doesn't keep up with its lower income housing production. That's almost no jurisdiction in California is able to produce enough lower income housing to keep up with that demand. It's more common for jurisdictions to be able to provide their above moderate income housing, but if you are in a jurisdiction where both of those are lacking, again, an applicant can take advantage of SB 35 by picking their affordability level of either 10% or 50%. The other component that I think in some ways will limit the reach of SB 35 because it carries a very significant financial implication for developers is the prevailing wage requirement. Projects that propose 10 or more units must pay prevailing wages for projects, and then out in the SACOG region, it's not a bay or coastal county, so jurisdictions with a population of 550,000 or more, any project that proposes 75 units or more must also use skilled and trained workforce, and that the definition of that that's included in SB 35 equates to union labor. So again, the combination of prevailing wage and a union requirement will make the application of SB 35 difficult to pencil in a lot of financial circumstances unless it was a project that already was going to use a project labor agreement or would be subject to prevailing wage requirements because of other funding sources that they were using to fund the project. But assuming that you find a project that is eligible for SB 35 and is still financially feasible, there are still a number of exclusions that will keep applicants from being able to invoke SB 35. The first that I have listed here I think is the most important. It's that a site must not have contained any housing occupied by tenants within the last 10 years. So that means if you have a project site that either currently has rental housing on it or even 9 years ago had rental housing on it that was demolished, you still can't use SB 35. And the reason that this is a limiting factor is that to use SB 35, you have to be on a site that's zoned for residential use or planned for residential use in the general plan. So finding a residential infill site that's zoned residential but that has not been used for residential, at least not used for rental residential projects, could be challenging. I think where you're most likely to see it will be in commercial or industrial areas that have been planned or rezoned for mixed use or infill housing opportunities, but that haven't begun that redevelopment process yet, so that they haven't contained housing. Other exclusions include prime agricultural land, wetlands, extreme fire hazard areas, hazardous waste sites, floodplains, fault zones, and there's a long list of specific physical exclusions that keep a project from being eligible to use SB 35. And there's also a restriction on the use of a subdivision map unless the application is being financed with low-income housing tax credit and commits to paying prevailing wage, or if it satisfies all the labor requirements, including the skilled and trained workforce that I discussed on the last slide. But if you do find a project that is eligible and is not excluded for one of those reasons, as I mentioned, SB 35 is a powerful tool. It does carry with it that CEQA exemption because it's a ministerial approval, and it also has reduced parking standards as a benefit for applicants. You can't require any more than one space per unit for any SB 35 project, and if a project is within half a mile of public transit, within an architecturally historically significant district, or even within a block of a car share vehicle, and we interpret that, I think, to be a car share vehicle station, like a drop-off or pickup point, then no parking can be required for an SB 35 project. So I'll also note these standards are very similar to they're identical to the parking restrictions that the legislature adopted last year in connection with the accessory dwelling unit restrictions. And I know a lot of jurisdictions, when they analyzed these locations, they found that no parking anywhere in their jurisdiction was required. So I think that this will have far-reaching implications and reduce parking requirements for projects that are able to qualify for SB 35. The other significant component to SB 35 is the time frame by which projects have to be processed and responded to. So for projects that have 150 or fewer housing units, within 60 days of project submittal, and this isn't complete projects like it is under the Housing Accountability Act, this is just application submittal. Within 60 days, the jurisdiction has to provide a list of all inconsistencies with objective zoning and design review standards that were in effect at the time the application was submitted. And if the time frame is not complied with, then the application is deemed consistent with all of those objective standards. And if you have a project that is consistent with all of your objective standards and subject to ministerial approval, there's then almost no way to reject that project. So this is a tight time frame for agencies to review and respond to applications that invoke SB 35. You do get 90 days for projects that are larger than 150 housing units. And I mentioned this briefly before, but it's worth highlighting again. The objective standards are consistent if they're being modified because of density bonus. They're also consistent if they are consistent with the general plan standards. Even if the zoning has a more restrictive standard, the project is consistent with objective standards if it's consistent with the general plan standards. So the general plan becomes the guiding force and really the ultimate regulatory authority for SB 35 projects. And then the last thing that I'll say about SB 35 is this additional time frame component. Within 90 days of submittal for 150 unit projects or smaller, within 180 days of submittal for larger projects, every agency must have completed any design review or public oversight of the housing development. And the fact that SB 35 allows for public oversight means that you can still have a planning commission hearing or some review of the project. However, that review is prohibited from in any way inhibiting, chilling, or precluding the ministerial approval of a project. And again, the majority of you are from public agencies. I'd imagine that you're hard-pressed to come up with a public hearing that would not inhibit, chill, or preclude the ministerial approval, or you wouldn't want to be in the position of going before your planning commission and the public and saying, here's a project, you have to approve it, you can't condition it or really take any action to modify it. So that that public oversight process is severely limited. And any review that you conduct, again, must be objective and strictly focused on assessing the compliance with those objective standards and the criteria that apply to streamline projects. So it's a very limited review process for projects that do end up qualifying. So as I mentioned, it's not clear exactly how many projects will qualify, so the ultimate scope of this may be somewhat limited. And with that, we'll turn our attention to some no-net loss statute, another key change in housing law, and Barb is going to take us through that.
So before talking about the no-net loss statute, I just want to bring everybody back to what's in your housing element, because the no-net loss statute is related to retaining sites that were designated for housing in your housing element. So those of you with public agencies know that a housing element has to show that it can accommodate the city's RENA, the number of units on the chart that Eric showed first. And this is a kind of typical list of sites shown in a community's RENA. You know, the zone was that. It could go up to 30 units an acre, so it was considered to be suitable for lower-income housing. And in the housing element, it was represented that 40 units could be built on the first site. So the no net loss bill has also, or statute has also been around for a long time. And initially it applied if a community wanted to approve a project on the, say, the first site shown here that had fewer than 40 units. Even though the site was designated for lower income housing, it didn't matter if the housing was market rate, so long as the units themselves, so long as 40 units, at least 40 units were built in the site. Nothing was triggered. But now it's also triggered when fewer units are built at the income level shown in the inventory. That's the key change in SB 166. And so here, even if a developer were to propose 40 units on the site, if all 40 units were not designated for lower income housing, SB 166 would be triggered. The statute has not been made applicable to charter cities, so at this point it's only applicable to counties and general law cities. So if either on the site that we looked at, either 40 units were, either fewer than 40 units were built in the site, or all 40 units were not lower income, the city would need to make findings. One is that the reduction, if there was a reduction in the number of units, was consistent with the general plan and housing element, that was consistent. But secondly, the city would need to make a finding that the remaining sites in the element are adequate at all income levels and has to quantify the unmet need in each income category and the remaining sites available. So again, thinking about our 40-unit site, if the city had designated, say, an extra 40, a site that could accommodate 40 more units than it needed for its to meet its lower income unit RENA, it could meet this, it could make this finding. But let's say that there were not enough sites left so that the city could theoretically build all 400 units of lower income housing. Then the city would need to, quote, identify additional adequate and available sites that are suitable for lower income housing so there's no net loss. The statute says that it's solely the city's responsibility to identify the additional sites unless the developer's application showed fewer units than were to be built in the site. So if the developer proposed only 30 units and the city didn't have enough sites left to make up those 10, the city or county could require the developer to find the additional sites. But if the developer proposes all 40 units but at market rates rather than lower income, the developer has no responsibility for identifying another site. The statute goes on to say that the city cannot deny the project because the developer's project results in a need for additional sites. So what happens if a developer is not proposing housing with either the number of units or not at the income level that was shown in the housing element? Well, the city or county might be able to find that the remaining sites included in the element are adequate to meet the RENA at all income levels. Maybe the city approved more units in some site that's shown in the inventory or had a lower income housing project approved elsewhere that could make up the difference. Maybe somebody had a density bonus, that would be a possibility. Maybe there are sites not in the housing elements, but that are suitable for lower income housing that can make up the difference. some of our clients said that they had not listed all of their suitable sites in the housing element and had extra sites available. And if all of that fails, another site has to be identified and made available for lower-income housing, which might involve upzoning. Which might involve upzoning. For the income category, that must happen within 180 days of the approval of the first project. If the city doesn't have enough sites in the housing element and identifies a site outside the housing element, there does not seem to be a requirement that the housing element be amended. But any additional sites identified have to be reported in the annual report under some new annual report requirements. It's not clear how CEQA review of whether the CEQA review of any necessary rezoning can be tied to the approval of the first project. There's language saying the city is not obligated to do it, but it doesn't say the city is prohibited from doing it. So the CEQA review provisions are somewhat confusing, should be reviewed. And then clients have asked whether cities can require that actually the lower income sites be 100%, actually be developed at 100% lower income and the moderate sites be developed at 100% moderate income. We don't believe that's possible because that would effectively reduce the value of the lower income sites and maybe the moderate income sites, the land value, to zero. And in the last California Supreme Court case on inclusionary, it said that the requirements cannot be, quote, confiscatory. What should cities do? I think any city or county that's subject to no net loss really wants to maximize required inclusionary requirements and require actual production of units, not allow fees to be provided instead. Some clients have asked whether accessory dwelling units can be required to be affordable. That does not, affordability standards do not seem to be listed as one of the standards that a city can apply to an ADU. So we are not sure that this is possible. And for any city that is city or county that is subject to this requirement, they need to keep a log of their housing element sites and look at where they sit right now. To some extent, this is changing the rules in the middle of the housing planning period. Before, cities and counties were good guys if they approved the number of units on the site that were shown in their housing element. Now, the approval of those projects may require some additional rezoning. In terms of some strategies we've thought about for the Housing Accountability Act and SB 35, we think it's critical to assemble a packet of all the standards applicable to housing projects, to go through SB 35 and have your own checklist with the eligibility requirements. It may be possible under the Housing Accountability Act to provide those standards to the applicant and ask the applicant to demonstrate consistency as part of a complete application. But that doesn't work for SB 35 because the standard for the consistency report has to be done after submittal, whether or not the application is complete. There's going to be SB2 money available for planning funds, and those might help to create more objective guidelines. We've thought about how conditions of approval can be applied or incorporated into the process because the Housing Accountability Act is generally only triggered for a denial or reduction in density, and it's unclear, and CEQA, cities will be providing statements to developers about whether they're consistent, but then the CEQA review will go on for a period longer. So it's going to complicate the review. And just putting it all together, we just have this slide here. Anytime you get a housing project, With no net loss, the first issue is it on a housing element site? And at that point, determine if the development might trigger the need to make those findings. With the Housing Accountability Act, the only issue is whether it's a housing development project. And with SB 35, is your city subject to it? Is the project eligible? And is it subject to any exclusions? We might mention with SB 35 that the developer needs to request the processing. The city doesn't need to determine for any housing application if SB 35 applies. So you would know when the developer comes in that they're requesting that. And with that, I see we're running out of time here. We were going to take questions, but maybe we should, I'm thinking maybe we should run through the rest of the slides briefly.
This is Monica speaking. We just have one question so far, so we could address this one question and then keep on moving with the presentation. That would be great. So the question is, does the density safe harbor for housing elements apply to SB 35 production, or do the affordable units need to be truly affordable?
It's the latter. The affordable units need to be truly affordable in order to demonstrate that you are keeping up with your production and not be eligible to SB 35. So if you're producing units that you can't demonstrate the affordability on, they might help satisfy the above moderate income category, but even if they're at a high density that you were counting on for your housing element, they won't count for those lower income units that are used to evaluate whether or not the jurisdiction is subject to SB 35.
So we will run through the remainder of the bills much faster. Both SB 35 and AB 18879 require changes in the current annual housing element reports. In addition, AB 879 directs HCD to look at the reasonableness of local development fees under the Mitigation Fee Act, but that report isn't due till 2019, so we don't need to look at it now. This is the current annual report form that each community needs to fill out, looking at individual projects and what the affordability of each project is. And this is determined by building permits. So the two bills require substantial additions to the annual reports. For the prior year, it has to look at applications, how many units were approved and disapproved, any sites that were rezoned to accommodate the RHNA under the housing element, and any sites identified for no net loss. In addition, something called a production report is required with the net new units with a, quote, completed entitlement, which is a new term, permitted or occupied, for sale and rent, again, the income category, and any projects reviewed under SB 35. HCD is supposed to publish and prepare new forms. The annual reports are due by April 1st of this year, but we're not sure whether HCD will be able to, whether the forms will be available, what obligations there are on a local agency if the forms aren't available. But we'd note that failure to submit 2 or more annual reports triggers SB 35 streamlining. Charter cities previously did not have to prepare annual reports, so some may not have submitted them for 2 or more years, and we're unclear if this trigger would apply to charter cities that weren't required to submit them. The return of rental inclusionary housing, I think, is really good news for local agencies. It restores the ability of cities and counties to adopt inclusionary housing for rental projects. It states that local governments can require new rental projects to include a percentage of affordable units. The one limitation is they have to provide alternative means of compliance to actual on-site production. but states that the alternatives may include, but are not limited to, a wide variety of possibilities. So this seems to provide a great deal of local discretion to local governments in deciding what the alternative means of compliance may be. If the ordinance was either adopted after September 15th of this year or requires more than 15% low income, and the city is producing less than 75% of its required above moderate income housing, HCD can ask that an economic feasibility study be submitted to it, and can basically, if HCD is unhappy with the study, it can limit the affordability requirement to 15% low income. So what does this mean? Some cities didn't bother changing their inclusionary ordinances after the Palmer decision was decided in 2018, and it looks like these can be implemented after January 1st, 2018. And if it was adopted before September 15th, HCD can't require an economic feasibility study review. The new ordinances are only subject to a possible review if they require more than 15% of the rental units to be affordable to low-income households, but it essentially gives a 15% low-income safe harbor for communities that desire to adopt this requirement. The provision is located in the zoning ordinance portions of the government code, so we recommend that these ordinances be adopted as part of a zoning ordinance. And finally, no nexus study is needed because the California Supreme Court said that inclusionary requirements are land use requirements like rent and price controls, and no nexus study is needed. Communities were doing nexus studies to justify affordable housing rental fees when they could not require rental affordable housing. So with that, I'm going to turn it over to Eric to finish up.
Thank you again, Barb. So if you guys are responding the way some of our other public agency folks have when we've been talking about this, you might be feeling like these new requirements are, especially with the date, it's a Halloween trick, but I get to talk about some of the treats that you get to go along with that, specifically SB 2 and SB 3. Both of these bills were enacted this year. SB 2 is to create a new permanent source for affordable housing that will be generated by document recording fees. And the current estimate is that between $200 and $300 million per year will be raised by this new recording fee that will be available for local governments and HCD to fund various housing development initiatives. SB 3 places a ballot measure for new bonds on the November 2018 ballot, and I'll talk about that more in just a moment. But first, just a couple of key notes on SB 2. The funds are allocated in two phases. During the first phase, year one, 50% of SB 2 money will be available to local governments, 50% will be available to HCD, but beginning in year two and beyond, 70% of the SB 2 money will be allocated for local government use, and 30% will be for HCD. So this could end up being, statewide at least, a fairly significant source. And looking at how it can be used, during the first year, it creates an opportunity for public agencies to focus on streamlining and create new planning documents related to streamlining applications. So as you heard during the first portion of our presentation, there's a real focus on objective standards. So to the extent that your jurisdiction doesn't have a full, robust library of planning documents, specific plans, design guidelines, and other standards that are objective, you can use some of this Phase 1 SB 2 money to create those. In year two and beyond, HCD will be coming up with guidelines to determine exactly how the money can be allocated, but in general, there's broad leeway for local jurisdictions to fund affordable housing construction and other related projects to support housing development. One interesting note about this is that jurisdictions can team up and use their money together to fund local projects. So that will be interesting to see how HCD writes its guidelines about how you can implement that, but that could help address a concern of there not being no jurisdiction getting enough money to do a single project, but perhaps there can be some pooled efforts to do some regional production. And then with SB3, this is more a note for the future. As I mentioned, in November 2018 on the ballot, there will be initiative for a bond program for $3 billion to fund existing state affordable housing programs and an additional $1 billion for a veterans home purchase program. So another significant investment if the voters approve of it, and we'll be interested to see how the Get Out the Vote initiatives go over the next year and how this fares. And hopefully it will end up creating another resource for jurisdictions to use to help meet its housing production needs. Another note for the future that I will call your attention to are some housing element requirements that were changed in connection with AB 1397 and AB 72. The first change is actually something that happens right away. HCD is now specifically authorized to revoke a finding of housing element compliance during a housing element cycle, and it can also refer violations of local housing elements directly to the Attorney General for enforcement. Both of these were things that HCD thought that it could do and did do occasionally previously, but now they have specific statutory authority to do that. And the other important thing to know about 1397 and AB 72 is that the next round of housing elements, there will be much more analysis required. They've imposed many more requirements in terms of how you identify what sites are available for housing and how you demonstrate that you're meeting your regional housing needs. So there's not too much that you need to do to prepare for that now, but over the coming years, be prepared to pay more attention to the new housing element requirements. Fortunately, for you in the Sacramento region, San Diego will be the first region subject to these new requirements, and then the Los Angeles region. So we'll have some other jurisdictions to look to and draw from for examples of how to comply with these new analysis requirements by the time the Sacramento area is going through its next housing element update cycle. I'll also mention 3 bills, SB 540, AB 73, and AB 1568, that were introduced to provide additional approaches for streamlining and give some additional tools to local districts, local agencies. The first is a workforce housing opportunity zone, or we've been calling them WHOs for short. And what this allows you to do is to create a specific plan and an EIR using either grants or no interest loans from HCD. And then once you have those documents, you can use them to streamline approvals for qualified housing projects in the future. I think that this is interesting because there is money from HCD available to help fund some of those planning initiatives. But I will note that if you're interested in streamlining approvals for housing, you have the authority to do that as a local jurisdiction already by making changes to your zoning code or having more ministerial actions directly in your local code. You don't need the specific authorization of a WHOS to accomplish this unless you specifically want the money from HCD to help with the planning effort. A housing sustainability district is a variation on a zoning district that also allows for streamlined housing approval. and jurisdictions that create housing sustainability districts will be eligible for incentive payments from HCD that can be used for different public improvements. Again, jurisdictions have the ability to create streamlined zoning districts already, so unless the HCD incentive payments are so attractive to lead you down this path, it might be something you could explore using your other local authorities. And then finally, the Neighborhood Infill Finance and Transit Improvement District, or NIFTY for short. This is a program that is designed to be an overlay on the Enhanced Infrastructure Finance District that can be used to fund affordable housing and infrastructure development within those EIFD areas. It does let jurisdictions pledge more of their sales tax and general taxes to development. It does have the advantage of letting you budget for future years, not just 1 year at a time. The catch with the NIFTY is that as an overlay to an IFD, it's not clear where that will be used because no jurisdictions have created EIFDs yet. So it's something that could become used in the future, but we haven't seen it pencil yet. And then the last topic I will cover, and then we'll just open the floor to questions, are the changes related to accessory dwelling units that were in AB 494 and SB 229. These changes were relatively small changes relative to last year's legislative efforts to refine ADU regulation, but they continue down the path of relaxing or limiting the amount of regulations local jurisdictions can place on ADUs. Specifically for ADUs that are being created in existing spaces, interior to an existing dwelling or an existing accessory space, they are now required to be approved in all districts that permit single-family homes, not just single-family districts. There are also additional limits to the ability to prohibit tandem parking and parking in setbacks. Previously, if your jurisdiction didn't allow that type of parking anywhere in the jurisdiction, you could prohibit it for ADUs, but that's no longer the case. They now have to be permitted unless you can make specific health and safety findings that are specified in the statute. And another fix that these enacted were related to the limits on utility fees. They've been expended. That limit on what fees can be charged in the connection with the creation of an ADU has been extended to special districts and certain utility companies themselves, as opposed to just local agencies that might be providing utilities. And it is important that you review your ADU ordinances and make sure that they are consistent with the provisions of state law, because this provision of the Government Code 65852.2 does provide that unless a local agency and a local ordinance is compliant with the Government Code, it's void, and you're only allowed to enforce the standards that are the minimal standards that are listed in the Government Code. So if you have additional local regulations, you want to make sure that they comply with the Government Code so that you can continue to enforce them. And that, as I mentioned, was the end of our prepared presentation and remarks. So with the rest of our time, we're happy to take any more questions.
Thank you so much, Eric and Barbara. That was a very informative presentation, and we do have a variety of questions, and we are going to jump into those right now. And more keep coming in. Okay, 1 second. I'm going to go here in time order if possible. Okay. If a jurisdiction is subject to no net loss would the housing element be out of compliance if the jurisdiction doesn't keep up with the no net loss find and or find site?
Well, let's see. Under the terms of the statute itself, the housing element wouldn't be out of compliance, but the city would be out of compliance because finding the sites doesn't require an amendment to the housing element as the statute is drafted. Some communities, though, do have in their housing element a statement that they will maintain the sites or that they'll comply with this provision of the code. And in that case, I guess someone could argue that what they're doing is inconsistent with the housing element. There's a provision, Eric mentioned that AB 72 allows HCD to, quote, decertify housing elements or say you're no longer in compliance with state law. And it allows HCD to look at any action or inaction that the community took. So I suppose if HCD were to become aware that a community, no longer had enough sites, I suppose they might use that as an excuse to say your housing element is no longer in compliance. But the statute itself doesn't require amendments to the housing element itself.
Okay, thank you. With the no net loss, is extremely low income, very low income, and low income all considered as one, or do we need to split them out?
No, they are all considered as one the way the statute is written. It uses the term lower income, which includes basically low income and below.
Great, thank you. When is the no net loss rule effective? And a follow-up question, do we have to make up for land developed as market rate previously in the housing element cycle?
Virtually all of these statutes are effective on January 1st, 2018. And the requirement to make up the sites would occur when you're considering a new development. Because the way it's drafted, it's triggered when you're approving a project on a housing element site. We are suggesting that people, go through the housing element, see what their situation is. Whether they do now have a deficit or whether they will have a deficit on the new rules in effect on January 1st, and then see what kind of a strategy they may want to develop to try to get any additional sites they might need.
So for SB 3, is the vote requirement proposed majority or 2/3?
Majority.
It's a simple majority.
Thank you. For the exclusions from SB 35, can motels or hotel sites be considered?
Oh, is that right?
Well, I think most local codes don't consider hotel and motel sites a residential use. I don't think that they would fall within the exclusion that keeps housing that was available to tenants and on a rental basis, since they're not usually treated like housing units. I think if it was an SRO or if there were other TOT exceptions to the property, then that might look more like residential use. If people are staying for more than 30 days and get tenant protections, then it's potentially a different analysis. But for a traditional commercial hotel, I don't think it should be excluded given the wording of SB 35.
Thank you. We have 2 more questions. AB 1397 says it's effective December 2028. However, this falls towards the end of the next housing element cycle for this for us, the 2021 to 2029. Is it applicable for our next cycle?
The particular provision, 65583.2, is difficult to parse out because there's two versions. The one that's version, and they basically have to do with what Marin County's default density was, whether it's 20 units an acre or 30 units an acre. And the piece of 1397 that's effective 2028 restores Marin County to 30 units an acre. But maybe just to summarize, yes, AB 1397 is effective January 1st, 2018, but housing elements don't need to be changed to comply with it until the next housing element cycle.
Next question. It is one viewer or one attendee's understanding that SB 166 does not offer any CEQA exemption for either the first site or the subsequently identified and made available site. Both have to undergo review as normally required. The second site is not required in advance of the approval of the first site. However, presumably, if the second site would require CEQA review for a rezone, etc., in order to be made available, then that would have to be completed within 180 days.
The second part of the sentence of the question is correct. If a rezone is required that requires CEQA review, that all must be completed within 180 days. During the discussions of this bill, it was suggested by local government and APA that the 180 days be extended to allow for CEQA review, and the authors refused to make that change. In terms of whether the environmental review of the of the rezoning could be required as part of the environmental review of the project that essentially requires the rezoning, the language is difficult to parse. It's not a clear exemption. It just says that an action that obligates a jurisdiction to identify and make available additional adequate sites creates no obligation under CEQA to identify, analyze, and mitigate the environmental impacts of that action as a reasonably foreseeable consequence of that action, which you see is difficult. So it says it creates no obligation, but it also does not necessarily prevent a community from doing so. I wish it had been written more clearly so we understood clearly what the authors intended.
Thank you. And then our final question that we've received, so again, this is also be the last call for webinar participants to send in your questions. For the purposes of SB 35, do sites zoned for residential use include commercial zones that allow residential development by right but aren't technically zoned residential?
Yeah, so it's the zones just have to permit residential use. It doesn't have to be named a residential use district. So if you have a commercial district that allows residential development or mixed use development, then a site within that district would be able to use SB 35.
Great. Thank you so much. And that brings us to the end of our webinar. I want to thank both Eric Phillips and Barbara Kautz very much for their time today. I know this was extremely informative to our region. We greatly appreciate your time. And a note to our webinar attendees, this webinar was recorded and will be provided to you via email with a link. And on behalf of all of our webinar attendees, the Sacramento Area Council of Governments, thank you, Barbara and Eric, and we look forward to working together again in the future.
Thank you.
Yeah, thanks for having us.
Thank you. Bye-bye.
Bye-bye.